Welcome to Historic Hanover Courthouse. I'm William Pollard, Clerk of the Court. Today is December 1st, 1763. Court will soon convene to hear a very important case that has garnered much attention. I have heard it referred to by some as the Parsons Cause. In order to understand what reality is a very complex event, let me provide you with a little background information. There are two important differences from today that are important in understanding this trial. First, in colonial Virginia, the noxious weed, tobacco, was used as a money supply. As Virginia's primary crop, it was more readily available than hard cash. Paper promissory notes for different amounts of tobacco served the same purpose as our paper money does today. Second, there was but one established state-supported religion, that was the Church of England. All Virginians, like it or not, were compelled to be members. The rulers of colonial Virginia, the House of Burgesses, had in 1696 set the salaries for the parson of the Church of England at 16,000 pounds of tobacco per year. This was collected each year from every landowner from each parish. This system worked well until about 1758. By that time, flaws in the system had become acute. There were a growing number of dissenters, also known as New Lights, who did not wish to belong to the Church of England. Hanover County had a great many of these dissenters, and they felt that they should not be taxed to support a church that they did not want to belong to. The tobacco crop in 1758 was a disaster, the first of several. Tobacco was in short supply, and as an emergency measure for the public good, the House of Burgesses passed the Two-Penny Act, which allowed parsons to be paid in cash rather than tobacco at the rate of 2 pence per pound of tobacco. Now, of course, because tobacco was so scarce, the actual selling price was much higher than 2 pence per pound. The Virginia parsons felt shortchanged. They decided to go to law. They sent a delegation to England and convinced King George to repeal the law. They then began to file suit in every county to recover their losses. Reverend James Marr of Fredericksville Parish was among the first. He chose to have his case tried in Hanover County because the chief defendant, Thomas Johnson, collector of Fredericksville Parish levies, was a political power in nearby Louisa County, where Fredericksville Parish was located. In November of 1763, the Reverend Marr won his case in this very building. The court ruled that he was due damages for lost wages, and a date of December 1st, 1763 was set for a trial to determine the amount that he would be awarded. It seemed like such a simple case. Many expected it to be a mere formality, but there are those who thought otherwise. And like with all important trials, decisions made in the courtroom can ripple throughout the land. Many people have come here today to Hanover Courthouse to sell their produce, to conduct business, or just to see what all the hullabaloo is about. The plaintiff, Reverend Marr, is ably represented by perhaps the premier lawyer in the area, Peter Lyons. Nearly 24 other parsons are in attendance to show their support and to weigh an outcome. A large settlement will strengthen their cases when they go to court. The Hanover County Sheriff, Mr. Tompkins, has selected 12 jurors to hear the case. Among them are several very active religious dissenters. Sheriff Tompkins surely must have been aware of that. The defendants are Thomas Johnson and Tarleton Brown. Their first lawyer in the case, Mr. Lewis, withdrew after having lost the verdict, dropping the seemingly hopeless case into the capable hands of a young obscuritarian, Mr. Patrick Henry Jr. Our Chief Magistrate is Colonel John Henry, who just also happens to be Patrick Henry's father. Court is now ready to convene the trial of the Parsons Cause.
Oyez, oyez, oyez! All upstanding. You may be seated. Silence is commanded while this court is sitting. Let all other persons who have anything to do with this matter draw near and give your attendance. Anyone have suit to their complaint to make, let them come forward and you shall be heard. God save the King and this colony of Virginia.
God save the King.
Gentlemen, thank you, Mr. Thomas. This court is hereby called and proclaimed on the first day of December in the year of our Lord, 1763. Mr. Clark, why do we stand?
We stand upon the writ of inquiry of damages in the case of Maury versus the collectors of Fredericksville Parish levies.
Very well, are you ready to proceed?
Yes, sir, I'm ready to proceed.
Mr. Sheriff, you call 12 qualified freeholders of honest repute to serve as jurymen?
Oh, yes, I have, sir.
Very well then. Mr. Pollard, I understand that the jury has been impaneled.
Yes, Your Honor.
Very well, let us proceed. Mr. Lyons, as counsel for the plaintiff, you may begin.
Your Honor, my client wishes to object to the persons chosen for the jury. In making his selection, the sheriff passed through a room full of quality gentlemen and out onto the courthouse green amongst the vulgar herd. My client neither knows nor has heard of many of these people. And those he does know, he recognizes as infamous religious dissenters. Surely the sheriff must have known that, as they are all acquaintances of his. Your Honor, my client would like a new jury.
Your Honor, this is a legally impaneled jury made up of 12 honest men. All are qualified to be jurors. They are unexceptional. No cause is shown to remove them.
Mr. Henry is correct. Jury selection will stand. Mr. Lyons.
As you so rule, sir. Your Honor, this is a very simple affair. As the court will recall, earlier this year, Your Honor entertained articles of demurrer and ruled in favor of my client, thus establishing as a point of law that my client is due damages. We come here today to establish the amount of those damages. In order to aid the jury in this determination, I submit the following facts. In 1696, Virginia's House of Burgesses established the salary of the clergy at 16,000 pounds of tobacco per year. The so-called Two-Penny Act of 1758 was passed by the Burgesses. And under the so-called Two-Penny Act, the parsons could be paid in cash money instead of tobacco at the rate of 2 pence per pound of tobacco. Thus, under the Two-Penny Act, my client was paid 144 pounds in cash. Well, our gracious sovereign Lord King George declared the Two-Penny Act to be null and void. The earlier ruling by this court establishes as a matter of law that my client is due damages. In order to establish the amount of those damages, we must look at what my client was paid under the Two-Penny Act, 144 pounds in cash, and what the fair market value of 16,000 pounds of tobacco would be. In order to establish that amount, I shall call forth expert witnesses.
Proceed.
I call Mr. Samuel Gist, merchant of Hanover.
The court calls Mr. Samuel Gist to come forward to be heard. You're Samuel Gist, merchant?
I am.
Place your right hand and hold writ. Will you, sir, make true answer to all such questions demanded of you in this matter? Will you speak the truth, the whole truth, and nothing but the truth, so help you God?
I shall.
Mr. Gist, you are a merchant in Hanover, are you not?
I am.
And, sir, is it safe to say that you are a successful merchant?
I do well enough, sir.
And as a successful merchant, you would no doubt know the selling price of various goods, such as tobacco.
I do, sir.
Mr. Gist, are you not being a wee bit modest? For indeed, are you not so well thought of as a businessman that you have been included in the recent formation of the Dismal Swamp Company, and thus you partner with such notable Virginia gentlemen as Mr. Nelson, Colonel Washington, and Mr. John Sim, Burgess from Hanover, and brother to our very own Mr. Henry.
I do have that honor, sir.
Very impressive, sir. Very impressive. So tell me, sir, in your expert opinion, what do you believe was the correct selling price of the tobacco in question?
6 pence per pound of tobacco, sir.
6 pence, not 2 pence.
6 pence, sir.
Huh. And since my client received only 144 pounds in cash, then the difference would be
266 pounds, 13 shillings and 4 pence, sir.
most remarkable, sir. According to my calculations, which of course I had to do by hand.
I am a merchant, sir.
Yes.
Numbers be part of me, friend.
Yes, sir. Yes, sir. Thank you, sir. Nothing further.
Mr. Henry, do you have any questions for the witness?
A few, Your Honor. Mr. Gist, your accent, sir, is not of old Virginia, yet it is different from that of my friend, Mr. Lyons, who I know is from Ireland. Out of curiosity, sir, what accent is that?
You know full well I am a Scot, sir. I was indentured here as a young man.
A Scot? You are a Scottish merchant, then. I am of Scottish descent myself, but I was born here. And you do well, sir.
I do well enough.
Oh, you must indeed be an expert, then, to prosper when the rest of us poor folk in Hanover must struggle to get by. I'm sure you must look forward to a long career.
Oh, well, there you would be wrong, sir. I shall be removing to England soon.
Removing to England? Why is that, sir? Easier chickens to pluck.
Oh, it is not so much that they be easier chickens to pluck, sir. There be more of them.
But what of your many friends here in Virginia?
I have no use for Virginia.
Check. These questions lack relevancy.
I withdraw them, sir. Your Honor, I stipulate that Mr. Gist is indeed an expert Scotch merchant who knows, to the penny, how much profit he can extract from his goods.
Mr. Gist, you are dismissed. Mr. Lyons, do you have further witness?
Yes, I call Mr. William McDowell and Richard from Hanover Town.
The court calls Mr. William McDowell to come forward to be heard. You're William McDowell, merchant, Hanover Town.
I am.
Place your right hand in holy writ. Will you, sir, make true answer to all such questions demanded of you? And will you speak the truth, the whole truth, and nothing but the truth, so help you God?
I will.
Mr. McDowell, you are a successful merchant in Hanover Town, are you not?
I make my living, but of course I am not so successful as Mr. Gist.
So, sir, in your opinion, what would be the selling price of tobacco in Mr. Corey's case?
In that, sir, I agree with Mr. Gist. 6 pence per pound of tobacco.
So, sir, in your opinion, the correct price is 6 pence per pound.
Yes, sir. In that, I agree with Mr. Gist.
Thank you. I have nothing further.
Mr. Henry?
From Hanover Town, how did the recent sale of building lots there go?
Not well, sir.
Well, not surprising, sir. Since the king has forbidden us to claim western lands, that would have driven the value of settled land too high for most of the common people in this area.
Yes, sir. Indeed, that is exactly what Mr. Gist says.
Did he indeed? So, sir, you feel the correct value of the tobacco in question to be 6 pence per pound of tobacco?
Yes, sir. In that, I agree with Mr. Gist.
You seem to have a high opinion of Mr. Gist.
I esteem Mr. Gist to be the finest and most knowledgeable tobacco merchant of my acquaintance.
And do you share Mr. Gist's low opinion of Virginians?
Well, Mr. Gist says, I mean to say, sir, no, sir, I do not.
That is all, sir. I merely wish to see if you had any thoughts in your head not placed there by Mr. Gist. Your Honor, I stipulate that Mr. McDowell is an expert in the price of tobacco.
Mr. McDowell, you're dismissed.
Your Honor, in order to save Mr. Lyons the trouble of calling forth every merchant in Hanover to the stand, the defense will further stipulate that the correct selling price of the tobacco in question was indeed 6 pence per pound of tobacco.
I see. Mr. Lyons, do you wish to call further witnesses?
Well, sir, in light of the defense stipulations, I have no need for further witnesses.
Mr. Henry, you have witnesses, sir?
No witnesses, Your Honor. The defense would like to enter into evidence the receipt which the clerk had previously received for 144 pounds cash paid to the plaintiff by my client as the total amount due under the two-penny law.
See that document?
Sir.
Mr. Garland, please enter this into the evidence. Anything further, Mr. Henry?
No, Your Honor.
You quite sure?
Yes, Your Honor.
Very well then. Mr. Lyons, you begin your closing arguments.
Gentlemen, narrowed down to the application of the law, this is a very clear case. In 1696, Virginia's House of Burgesses established the salary of the clergy to be 16,000 pounds of tobacco per year. This act was sanctioned by the Crown and it became law. The so-called Two-Penny Act of 1758 was not so sanctioned. Although passed by the Burgesses, a gracious sovereign Lord King George not only declared it to be null and void, but he rebuked our assembly and our governor for its passage. The earlier finding of this court in favor of my client establishes as a matter of law that you must find damages. The only question is the amount of those damages. That amount can easily be arrived at by determining the amount that my client was paid under the Two-Penny Act, 144 pounds in cash, and subtracting from it the amount that my client would have been paid when the tobacco sold on the fair market. Now, expert testimony has revealed that the difference is 266 pounds, 13 shillings, and 4 pence. That is the amount that my client seeks. That is the law, and that is justice. But when the tobacco crop was plentiful, and the price per pound small, neither my client nor any other members of the clergy voiced any objection. They accepted their salary even when it was a mere pittance. Is it not now justice, when the price of tobacco is a few pence per pound more, that they should reap their reward? These godly men are the ones who have united you in holy matrimony, who have christened your children, who have day by day ministered to your spiritual needs. They have sat by the bedside of your sick ones, and they have comforted you in your times of grief and sorrow. Yea, they have stood by the grave with you and administered last rites to your loved ones. These men have given their hearts to you, and I ask you to return that in a true Christian spirit. Thank you.
Mr. Henry, you make your argument.
All law books discussing English common law tell us, and a moment's contemplation will confirm, that the right of a trial by jury is a thing which we as free men should value highly. It is a basic protection of our lives, our liberties, and our property. As jurymen, you are protectors of those rights and must be bold and diligent in your sworn duty. In 1607, when our forebears first settled this land, they brought with them a charter from the king. This charter confirmed upon them and their descendants forever all rights, privileges, and liberties of free Englishmen. Along with these rights, they also brought another jewel from the mother country, the common law of England. With these two bulwarks, but with little further help from the crown, our forefathers tamed this wilderness and created this land we now love so well. In 1619, because of our isolation, we were granted by the king the right to form a grand assembly, our House of Burgesses, that we might enact laws for the common good. In the course of time, many such laws helpful to the public have been enacted by the House. These laws have helped succor countless numbers of innocent men, women, and children. We rejoice in the right to elect our own leaders and guide our own destinies. The Two-Penny Act of 1758 was one such just law. In a time of danger and distress, our elected leaders sought to ease the burden of the afflicted. But we are told that the king has declared this law invalid. A just law to relieve the suffering of his people has been brushed aside by His Majesty King George. Enacted by the elected representatives of his people, it becomes null and void when the crown hears the pleas of the privileged, but not the cries of his abject subjects. Gentlemen, a king and those he rules share a solemn compact. In exchange for their obedience, a king must rule in such a way to bring happiness to his subjects. But compacts must be obeyed by both parties. I submit that for a sovereign to disallow such a wholesome law as the Two-Penny Act in such a manner is an instance of misrule and breaks the compact between a king and his subjects. It may even be called tyranny.
Watch what you say, sir.
It leaves the people no choice but to use their natural right to consult for their own safety.
Treason, sir, treason. Mr. Sheriff, quiet the crowd.
Order is demanded in the court.
Your Honor, I must object. How is it you give Mr. Henry such bold license? How is it that you hear a man speak treason and say absolutely nothing?
I have heard no man here speak treason, Mr. Lyons. Proceed. May continue, Mr. Henry.
If I have offended in my speech, I must apologize. I merely speak the truth as I see it. Different men often see the same subject in different lights. Very well then. Mr. Lyons has spoken with much warmth about the deserving nature of his client and the other members of the clergy, but it seems to me that the purpose of an established church is to enforce obedience to civil sanctions. How does this comport with their opposition in this case to a law passed for the common good by the House of Burgesses? Instead of making them useful members of society, does this not make them enemies of the community? Should they not be instead of rewarded, punished with severity? Yes, gentlemen, we have heard a great deal about the benevolence and holy zeal of our reverend clergy, but how is that manifested? Do they manifest their zeal in the cause of religion and humanity by practicing the mild and benevolent precepts of the gospel of Jesus? Do they feed the hungry and clothe the naked? Oh no, gentlemen! Instead of feeding the hungry and clothing the naked, these rapacious harpies would, with their powers equal to their will, snatch from the heart of his honest parishioner his last hoe cake, the widow and her orphan children, the last milk cow, the last bed, nay, the last blanket from the lying-in woman. Mr. Lyons speaks of their past sacrifices in pain. Yet I see near 24 here to see what rewards their greed may harvest. Reverend Mr. Odom, whose foxhounds are credited with being the best in all Virginia. Yes, he is indeed in need of damages. To keep 36 fine dogs and go hunting 3 times a week must indeed take much money. Reverend Mr. Dowd, has another ship arrived in Fredericksburg with a load of fine Madeira wine? But then you must need money to keep your famed cellars well stocked. Oh, do not think I do not see you, Reverend Mr. Cumberland. Indeed, how could I miss you, sir? The very bench groans beneath your weight. It must take a great deal of money to keep your table renewed. Do not be deceived, gentlemen. This is not an issue of a few pence per pound of tobacco. This is a case concerned with freedom. Freedom for Virginia to govern itself. Freedom to choose who shall minister to our spiritual needs. Freedom from tyranny in whatever form it may take. Gentlemen, you have taken an oath to obey the law. But it is a law of nature that men may make their own laws for their own safety and the common good. Unless you wish to fashion the chains of bondage around your own necks, you must make an example of this plaintiff for all those who would dispute the rights of free men to make their own laws. Mr. Lyons has told you that it is a point of law that you must find damages for the Reverend Mr. Morey. Very well, I cannot dispute this point. What he did not tell you is that it is your right to set the amount of those damages. Award them as you must, but send a message to tyrants everywhere by awarding only 1 penny in damages. Thank you.
Mr. Lyons, you wish to write a rebuttal?
Oh, indeed I do, sir. Indeed I do. Gentlemen, let me join you in admiration. Let us pause and take a deep breath. We have truly witnessed a prodigy of oratory. Like you, I have felt the passion of Mr. Henry's speech. But like me, you must not let it blind you to your duty. All the flights of fancy in the world did not change the law 1 iota, and it is the law, gentlemen, that you must find damages for my client. It is your sworn duty. And Mr. Henry has said that you may, if you so choose, award less than the amount that we are seeking. But you may also, if you so choose, award more than my client seeks. You may award court costs and fees, but my client does not seek these. All he asks for is what he is rightly due. Mr. Henry has attacked the members of the clergy, these godly men who have ministered to your very spiritual needs. By his sweeping accusations, he loses all propriety and includes his own uncle, your own parson, a man we know to be above reproach. He casts stones where I would not dare. And Mr. Henry has spoken treasonous remarks. And remember, gentlemen, that treason, no matter how well spoken, is still a crime. Mr. Henry is young, and he has much to learn. In his folly, he remembers that the first duty of a lawyer is to uphold the law. For a land without laws is a land of chaos, anarchy, misery. Mr. Henry speaks of a higher law. He seeks some utopia outside of the law. He chases a dream, gentlemen. He warns you that we would place around your necks the chains of bondage. But what he does not tell you is that he would instead place there the hangman's noose of lawlessness. Do not listen to the siren song, gentlemen. All that my client seeks is what he is justly due. I ask you, and I expect you to do your duty faithfully. Thank you.
Gentlemen, this court will now enter into a recess while the jury deliberates on the verdict. Mr. Sheriff, you will escort the jury to a place where they may deliberate.
All rise upstanding. Jury members, follow me.
Mr. Sheriff, has the jury chosen a foreman?
Yes, I have, sir.
And has the jury's verdict been delivered to the clerk?
Yes, it has, sir.
Mr. Palmer, you will now read the verdict.
We, the jury, find for the plaintiff and award damages in the amount of 1 penny.
Your Honor, I move that the verdict be stricken.
Denied.
I move for mistrial.
Denied.
That I seek an appeal.
Well, sir, there you have it. An appeal is your client's right. See the clerk with the proper writ.
Allow me a moment to gaze into the future. The verdict caused quite a stir in Virginia, and Reverend Maury never did appeal. In effect, Mr. Henry's argument meant that the 2 penny act stood. Think about that the next time you want to put in 2 cents worth. John Adams said that the revolution occurred in the hearts and minds of men long before the actual shooting started. This case has been called by some the first step in the American Revolution. It was more than Reverend Maury losing out on a few pennies per pound of tobacco. It was about freedom. And Hanover can justly be proud that the man whose cry of liberty or death that inspired a nation was born and began his career here. The courage of the Hanover jurors was also shown by their decision to uphold justice over the law. They called into question the 2 primary powers in colonial Virginia, the king and the clergy. And as much as we complain today about the rapid pace of life, think about this. Within 20 years of this case, America had thrown off her king and become a free republic and a beacon of hope for the rest of the world. This was due in no small part to the efforts of Patrick Henry. Virginia had put aside the state sponsorship of the church and written into law the right of religious freedom, again, aided by Henry. And within 20 years, Patrick Henry, an obscure country lord from Hanover, became the first elected governor of the great Commonwealth of Virginia.